So actually the committee says, yes, states can refuse to give certain treatments, especially if providing those treatments would constitute a kind of discrimination. Inappropriate health resource allocation can lead to discrimination that may not be overt. For example, investments should not disproportionately favor expensive curative health services at the detriment of other things. So you could apply that to Subramuni. I mean, this is 2000, the Subramuni case was in 97, but if you go back to the reasoning of the court, you could say, if you would give renal dialysis to everyone who needs it, that may lead to a discrimination. If, and I would add, and that's important, if and only if providing that treatment would lead to the discrimination of other people who may need less expensive, more effective, or more efficient treatments. And then I'm wondering if you would have applied that principle of non-discrimination rather than this reasonableness, would the outcome of the case have been the same? And I'm not sure. I don't know enough about South Africa's health system, but I know there are some issues with a very high level of expenditure on tertiary healthcare, a legacy of apartheid, and still limited resources for primary healthcare. Now, where does renal dialysis fit in here? Would it be considered now as one of the more efficient, if you would save money on the highest or the most expensive or not? I don't know, but it's interesting, and I think it would be an interesting exercise to do that again, retroactively, and say, okay, now that we have ratified the International Covenant, and that we're bound by this principle of non-discrimination, does that make a difference? Again, I don't know, but I think there's an option. So I think in terms of influence, I think what the Subramuni case and other cases did was it kind of saved the right to health from its caricature. I'm a lawyer, but I've worked all my life with medical or health institutions. First NGOs, Doctors Without Borders, then the Institute of Tropical Medicine in Antwerp, now the London School of Hygiene and Tropical Medicine. And still today I get comments from my colleagues with a medical background saying the right to health doesn't make any sense because, yeah, it means that everyone has the same right to the same treatment everywhere in the world. And so this is Richard Feachin making a caricature of that, saying if some people in San Francisco get a treatment, then everyone in the world should have it. I think the Subramuni case and the way that it's very carefully formulated actually helps to counter that caricature. Say, no, that's not what the right to health is about. It's actually more sophisticated. And so that, I think, is the positive legacy. The legacy where I have questions about was already mentioned by Lisa Foreman. I think this whole accountability for reasonableness, which is now becoming really prominent, not only in Africa, but in different parts of the world, as the main litmus test, is problematic. It's not demanding enough. I think the principle of non-discrimination and testing whether providing a treatment leads to discrimination of other people is more demanding. And so I hope we will have some discussion about that, this accountability for reasonableness. And that's where I'm going to end.
Please let me ask that all the panelists come up front. We'll turn off the projector so that it's not in everyone's eyes. We'll begin the question and answer session, and we've got, as promised, about a half an hour. So thank you to everyone for staying on time and helping us to think through some of these issues. Do we need to use a microphone for questions? Perfect. As questions appear, if you could pass the microphone, I think that would be helpful. Perfect. And I will go and hang out at the end. But I want to open the conversation in thinking about the theme of the panel and getting the panelists' reactions to that theme on South Africa's role in informing health and human rights. We focused largely over the course of the session on South Africa's implementation of international human rights standards. But how has South Africa in turn informed the world? How has South Africa proven a leader and an example for human rights advancement for public health throughout the world? Great.
I think I already tried to answer that. So I certainly think that civil society organizations of South Africa are an example for civil society organizations in other parts of the world. And they're, I mean, everywhere where you go in Africa, but also in Latin America, people are aware of what has happened here and what is happening here. I think that's very important, and it's particular. I think it's one of the legacies of apartheid, or the struggle against apartheid, to embrace law and to use law. That's very important. And the other one, I think, is this reasonableness. That's an important legacy, and where I have some doubts whether, I think it's questionable, and I hope it will also be questioned in South Africa and perhaps modified or made strict. I mean, Grootboom is already more demanding than Subramoen. So there is an evolution, but I would like to see that evolution go further because it really has an impact in other parts of the world.
Open up to questions. Well, sorry, did you want to finish that thought? We have to pass the microphones.
Yeah, perhaps I'll just add to that. I think the South African Constitution makes provision for us to look at international law. Well, we, of course, must look at international law. And they may consider other jurisdictions as well. So that's a specific part of our Constitution, so that has become part of our judicial culture as well. I think if we look at Canada, for instance, just from a very simple count on the online database of South African cases, in about 25% of all constitutional court judgments, there were references to Canada. 25%, that's quite significant, I think. So the question, but then one reverse question, in how many judgments of the Canadian Supreme Court or the American Supreme Court will there be a reference to South African case law or even to international law for that matter? So I think my point is that I think all of our legal systems can learn a great deal from each other. And I think currently South Africa is perhaps to a large extent a receiver in that learning process. And perhaps it would be, well, I think it will entail a change of legal culture for lawyers and judges in other jurisdictions, at least common law jurisdictions, to also take a little bit more note of what's going on in South Africa.
And Lisa picks up on that when she looks at parallel language across countries, that ideas that begin in South Africa are being picked up by other nations, both in constitutional law, legislation, and Supreme Court jurisprudence.
Yeah, I was going to say probably the two important lessons to me is how the notion of reasonableness can and should be interpreted. And second thing is how progressive realization can and should work. They've been quite influential in how countries have been ramping up their access to whatever it may be. So I think those two notions were known before South Africa's constitution, but how it was applied and how, as Lisa mentioned, the Constitutional Court has emphasized a reasonable and flexible policy-making approach. So you find that there's flexible and reasonable policy-making reformation on an ongoing basis in South Africa. You don't wait X number of years. If new evidence comes up, you change, you have new guidelines. So I think those are very important, and I think that they existed before South Africa, but what South Africa has done is shown a very clear link between jurisprudential decision-making and actual enactment on the ground. And the other thing, I just was a very minor thing, I remember a few years ago, one of the US Supreme Court Justices, Sandra O'Connor, I think, gave a speech And what she had done was, which caused huge controversy in the US, was showed that new jurisdictions around the world, new countries that are enacting constitutions were actually basing their constitution mainly on South Africa's human rights framework, not in the US framework, and said that that's probably a model for the way to go. And she came under huge criticism in the US for even suggesting that African countries' human rights framework should be considered as a template framework. But she defended it by saying, this is actually the better way to go. Our constitution is over 200 years old. It's not a model and a good template for countries to use. And the South African constitution is in fact a better model to use.
I'll maybe just make two brief points. I mean, one of the places we're seeing real impact is in groups in the region who are taking some of the strategies from South Africa's Pine and do incredibly innovative things with the right health in context that people would have weren't necessarily susceptible to that. I'm thinking specifically of our colleague Moses Malunga's work in Uganda with Seaherd, where there's not an enforceable health right, but him and his group are enforcing the right to health, attempting to enforce the right to health through the Constitution. And I think a lot of that is modeled on what's been done here. I have other pieces, but I'd rather maybe just take comments.
Perfect. And where is the microphone? Alicia?
I have it. Alicia, this is not so much about South Africa. I'll try to give it a twist about South Africa. It's mostly a question to Doddridge. You talked about moral enhancement, but of course in news there's been a lot on genetic engineering and gene therapies. And I guess my question, I was fascinated by your talk and by this concept, how you would reason on the elimination of very serious genetically transferred diseases, which is not a theoretical question anymore. There is in vivo and ex vivo work being done. There are live human patients being treated. It's moved from the lab to the clinic. So I would be interested in your comments about that. And then also to say that a lot of the legacy of South Africa was fighting against presumed intellectual property of the pharmaceutical companies, and of course in genetic therapies they are precision, so you can't have generics. So just if you could respond to that.
If I can just ask a quick question for clarity, the elimination of these serious diseases, would that be through somatic cell therapies or would that be through germline engineering?
So currently you're working at the somatic level, but of course the specter of germline editing is, since the Chinese doctor did it, is floating around and we don't know how long. But currently it is somatic.
Yeah. Well, I think what interests me specifically is germline engineering. That's
what would you say about the germline?
It is of course now also the focus of my group's research there at UKZN's law school with the medical school. Well, I think I recently read an article that identified a total of 61 international ethics instruments that relate to this question, and it breaks them up into some are profoundly against, others still perceive the possibility of it. So it's quite mixed. There's certainly not any kind of universal consensus on it. I think we're still a long way away from that, so at least we can prepare ourselves morally and legally. My position is, and this is at a very general level, is that we have a duty to improve people's lives. We have a duty to try to promote human flourishing. And if we can eliminate a disease through safe and effective germline editing, I in fact think we've got an ethical duty to pursue that. That is my short answer.
That is provocative.
My name is Kelly Krogman. My question to Lisa. In terms of analysing the state's duty in terms of health and in South Africa, healthcare right. What are your views in considering negative notions of that right? Ensuring that, especially in the wave of the NCDs coming in and becoming a serious threat as they are, the state's duty to stop behaviours or influences in terms of the social capital of health to sort of mitigate these issues, and in terms of the litigious nature that could take, what would your views be on that? And then actually I've got a question for you, if I could be very indulgent, in terms of people's ability to become owners of their intellectual property as it becomes their genetic code. I'm thinking specifically of people that might have the ability to create various medicines from their bloods, people with red proteins, or if you look at the history of the HeLa cell in terms of how people have profiteered off a lack of consent for the use, and then you balance it with old samples being taken from 100 years ago and that's creating vaccines. How we could get to a point where people can take autonomy over their genetic information as a form of intellectual property. I'm being very deep on two questions.
So, look, clearly, the state holds a range of respect, protect. What's the fourth one under the Constitution? Promote and fulfill. Respect, protect, fulfill under General Comment 14, and they encompass a range of state action. I think my question would be, so to answer your question straightforwardly in terms of the doctrine, absolutely. It extends to negative duties as much as to positive duties. My question though would be why one would characterize those responsibilities as negative. And this is part of my hesitation around, I think we've internalized the negative, positive distinctions of old in ways that are not necessarily always that helpful or that will continue to be that useful. I found Henry Shou's book on basic rights quite mind-blowing when I read it, in terms of the way that he speaks really forcefully to the canard in some sense of applying the negative positive paradigm when it comes to rights and what it is that we're really required to do. And so I remain a little reluctant. I know that we are now, we've clarified that all rights have positive and negative rights and all positive and negative duties. However, I worry about the inappropriateness of that paradigm. Even on the one that you presented, what is negative about preventing NCD really? Yeah.
Well, what's the answer regarding intellectual property to me?
Yeah.
Oh, okay. I'm not really that much of an intellectual property expert, but I will give it a shot. I think in this new context of the genetic revolution, it's an immensely important question. I think that individuals do have personality rights regarding their own genetic information, but I wouldn't call it intellectual property rights. I think the whole theory and dogma relating to intellectual property rights is about some creative or intellectual input in creating something, and not just what we just find in nature. So I would acknowledge a personality right in your own genetic information, but I wouldn't go as far as calling it any intellectual property right. That, I think, would only follow once some scientific research group has done further research or find a certain method of application of the human genetic material. An interesting development now in South African law, because it's always been a little bit unclear as to what is the position actually regarding human genetic, human biological material in general, and also the genetic information contained in it. That is also one of the objectives of my research group to now, in attempt to get some authoritative position on it. A recent development is that the Minister of Health made a model material transfer agreement that was published in the government that specifically refers to human biological material as being owned by the provider, by the human research participant. So it would seem as if that question or that particular uncertainty coming from our common law about the ownership of human biological material at least has been answered now. But of course the genetic information contained therein is still a further question. So I think I've only provided you with some broad ideas here. Hopefully the specifics will follow. Watch this space.
Thank you so much for, is this on?
Yeah.
Okay. I'm Lauren Conn from the University of Cape Town here in the law faculty, and I have some general comments and questions for the panelists. Firstly, just to say, Jerome, the statistics have blown my mind. I mean, I'm absolutely, completely astounded by those stats. I teach social economic rights to the first law to the constitutional law students, so I plan on quoting something there because I think they put everything in perspective. We should start with the stats. Then, is it pronounced Dorich? Donrich. My one comment in relation to your presentation is the link we can make between high levels of IQ and the validity of being able to program or test for that and linking that to autonomy. I think that's, you mentioned at the very end, but that should be permissible insofar as it speaks to autonomy, and I just want to get anything further to add there, because I think that's, as a young parent myself, I'm big on autonomy. It's the point of divergence between my mother-in-law and I. Because I think children, we must respect their autonomy. They're still little people after all. And then my comments in relation to Vorik, is it pronounced like that? You sound Dutch. You're from Holland originally.
Belgium.
Belgium, okay. And Lisa speaks generally to what you spoke about rationality and reasonableness and non-discrimination. I unfortunately missed the esteemed Liebenberg presentation on non-discrimination, what you mentioned at the outset. But I'm interested in how we sort of hang these notions together. You know, reasonableness, rationality, non-discrimination, minimum core flexibility. It's a challenge. I mean, reasonableness initially got quite a bad rap, as I understand in the beginning, because there was this push for acceptance of minimum core. And I mean, for what it's worth, agree with what our Constitutional Court has said, that you can't square that with the clear text of our Constitution, which puts reasonableness front and center, but also which is context specific, which, as you say, is flexible, can change over time, and can be relevant to working out what a minimum core should be in particular situations. I for one, think it's right. I don't think that Grootboom developed this notion of reasonableness, as you put it. I think it was clearly explicit. It's explicit in our Constitution. And where Subramani, for me, applied a more rationality standard, Grootboom took it further and actually carved out elements that we can hang on to, working on what is reasonable in a particular case. So I think that, and I agree for what it's worth, that Massachusetts did a bit of a bad turn, and it became a little bit more retrogressive in its approach. It's the one O'Regan judgment that I think is quite thin, oddly, because I find it very difficult to disagree with it normally. But I wonder what you all think on how we, what is the difference between the so-called non-discrimination standard, reasonableness, mere rationality as was applied in Subramani, and how do we square it all and what is best? Because I need to teach this to my students, so I'm very interested to hear what you all have to say. Thank you.
Thanks. So I think my comments and questions follow very well from what Lauren was saying. So just a couple of brief observations. Firstly, to Lisa, I think one must be careful of characterizing Article 2.1 and 26.2 and 27.2 as limitations of the right. They can be limitations, but they also impose obligations to make progress, to take reasonable steps, to mobilize the maximum of available resources. So the committee, very much in its jurisprudence on maximum available resources, interrogates states as to their fiscal policy. For example, are they mobilizing maximum tax revenue? How are they expending? Are they losing resources through corruption and so forth? So it's not, I don't see it as a limitation, but a description of the positive duties on states. And inherent in it is an accountability to certain normative standards. Secondly, to Gorick, I think the notion of discrimination is very much tied into the reasonableness standard, so it ties very much to the criteria you apply. It's a very different reasonableness test to the reasonableness in delict or in administrative law, one that weights certain values like human dignity very highly. And I think I agree with Lisa, the criteria for fleshing out this reasonableness standard is very important, so it doesn't become a retreat into judicial deference as it was in the Mazibuko case. So I think very much some of the criteria are caught and the committee has developed, which unifies, and I think this speaks to Lauren's point as well, unifies concepts of minimum core, non-discrimination, procedural obligations. That is the strength of the reasonableness paradigm, but it needs to be given flesh to really do that work.
If you would like, I want to open that up. Yeah. Perfect.
Shall I think I still have a question for us.
We'll come. Let's start at the end.
Thank you for that wonderful, I think those two questions they really bring a lot of the issues together. And so maybe I'll answer Lauren, you, and maybe touch on some of those elements around what you raised, Sandra. I think there's a real challenge in the South African court's approach, in the rejection of core obligations as relevant. I know that there have been dicta that say that it may have relevance to reasonableness, but I also understand the challenge in that, because as somebody who's focused, I spent a fair bit of time in the last few years looking at core obligations under the right to health and the committee's interpretation. And General Comment 14 it's not a sustainable interpretation of core obligations under the right to health, conceptually and procedurally. To say that essential medicines fits into a core obligation under the right to health, but reproductive health care doesn't. How do you square that in with any sense of, primary health care or health? There was a decision made around splitting core to comparable, which I think that the committee certainly has stepped away from in later. I think it was kind of a 2 a.m. decision, what goes in, what goes out, and made a decision around what would go into the core, particularly given the strength of the obligation. That's the other part that I see. So the committee in General Comment 14 says non-derogable core obligations not subject to progressive realization. And they've stepped away from that too. I think maybe one other general comment maybe spoke of non-derogable obligations, and then subsequently they returned to more of a general comment 3 standard of how to assess non-compliance. So I do understand the difficulty for domestic courts with the interpretation of core obligations that we have in General Comment 14, but I also think that there's a tremendous lost opportunity to flesh out something like the reasonableness standard and make sure that you have something that sketches a priority, and that should trigger a more significant, a stricter scrutiny, a stricter level of accountability for state allegations of resource limitations or progressive realization when you're looking at significant deprivation. And so that's where I think that, it's one of the pieces where a more integrated interpretation of reasonableness in the context of the international framework on the right to health and on economic social culture would be more effective. And then I think also something that Boric, you made the argument really explicitly, and that I in the work of yours that I've read, that notion that we need a much more we need to take a more indivisible interpretation of economic, social, and cultural rights. And my concern with the reasonableness test is that that the Constitutional Court treats any positive duties as as conceptually, substantively different in nature. And whether those positive duties arise under civil and political right or under an economic and social right, they're subject to reasonableness review and not Section 36 limitations. And that seems hard to square.
And it's also hard to square that with this notion of positive and negative duties flowing from rights, because then you get those cases like JAFTA, where it's a breach of the negative duty, and then the challenge is via Section 6. So, you know, how is it that there's a more onerous standard on the one hand, but less on the other hand? I mean, it's a bit of a mess.
But I think that's exactly the reason why I'm interested in comparing discrimination with reasonableness, because as much as I agree with the artificiality of the distinction between positive and negative rights, it does have an impact. It does have an impact on how courts think, but also on how human rights NGOs work. And a lot of the strategies developed by human rights organizations are developed for negative rights, for freedoms, where the corresponding obligation is negative and therefore the violation is a positive one and easy to identify. A state puts someone into prison for voicing a certain opinion. And then when the violation is easy to identify, that gives you a number of strategies and litigation, naming and shaming, etc. When the obligation is positive to do something, to provide healthcare or to reduce advertising for sugar, sweetened beverages, etc., the non-compliance is more difficult to identify.
Yeah.
And I think a lot of NGOs still struggle with that. How can we fight this? And there I think kind of merging non-discrimination with reasonableness and saying the duty, the obligation of the state is to show that they are unable to do this unless they would discriminate against others or use scarce resources. That puts the bar a little bit higher for states and makes it easier for civil society organizations to say our government is in non-compliance.
Yeah.
And that's the area where I'm interested. I don't think they're contradictory or different. I think they're quite close to each other. But making it a bit more demanding would be useful, I think.
Yes.
I think one thing that Sandra mentioned was open democracy. And I think the concept of openness is a concept that's widely underutilized in our jurisprudence. It's a core concept of our Constitution, but only at the very beginning of our constitutional jurisprudence was there any attempt to actually analyze openness, and was in the judgment of Ackerman, who is now retired here, Laurie Ackerman here in Cape Town. And he connected it specifically with Karl Popper's philosophy of an open society and its enemies. I don't know if you're familiar with that word, political philosophy. But in short, well, that's like a treasure trove from which we can learn, especially in the context of health rights, because the open society, as conceptualized by Popper, is a society based on freedom, rationality, and humaneness, which includes that all avoidable suffering must be avoided. So that's not just in short, but I think that's part of the interpretation clause, the limitation clause, all of that in our Constitution, and I think that can potentially be used in a useful way in future. I would like to quickly answer your question. There's of course an ongoing debate about intelligence, but perhaps an answer to you. You're a mother yourself. Are you trying to develop your child intellectually, stimulate her intellect?
Well, I try and stay sane as well, but
and if you're trying to stimulate your child's intellect, do you think that that will open up more future possibilities to a child?
Certainly.
Well, I think there you have at least a prima facie.
So, cognizant of the fact that we have more questions than we have time, there are 3 questions I want to get to, 1, 2, and 3, and then I'm going to let the panelists answer all of them and wrap up their thoughts in a way that hopefully will lead us into the break and stimulate further conversation over that half an hour of coffee. So, Matthew.
Thank you. Karen Tree from Stellenbosch University.
So Dominic, you spoke about intelligence. What type of intelligence is it? And how are you going to assess the potential donors in terms of this intelligence?
I protected myself against that question by specifically saying that we will have to evaluate this on a case-by-case basis.
Okay, and in terms of biological material, there's already some empirical evidence around what research participants and patients regard as ownership in terms of biological material. The MTA that you referred to is extremely controversial and
It is.
under review by the Department of Health currently.
It is, yes.
Thank you very much. Stephanie Dacron from the University of Geneva. It will be very short. I was really impressed by the statistic you gave us, Jérôme. I was wondering, when we talk about health and human rights, we speak about cases and implementation in the field of HIV. So what is the situation in South Africa with regard to the right to health and other situation, access to primary health care, other diseases that are also problematic, etc. Thank you.
One second. Yes.
Thank you very much for all the presentations. My question is to Professor Lisa and Gorik. With regards to the exploitation of the principle of reasonableness, what do you think the implications will be for the justification or the justiciation of the right to health in Latin America, for example, and the direction it is going, especially considering the fact that we now know that in hindsight, the trajectory of those kind of cases have weakened their health systems. And what do you think is the way forward for emerging countries that are still trying to navigate how they feel right to health?
Okay. Shall we have the speakers wrap up in the order they presented?
I think that's an excellent question. I'm not a Latin America content expert. I wonder about the transferability of the common law like that into the civil law systems. And I know that some of the real differences between the legal systems maybe account for certainly the numbers and the scale and potentially the impact in the sense of sort of a lot of them having the tutela and amparo claims having one-on-one type, not precedential value, although obviously not necessarily all the case. But I think the contrast between the two models of enforcement are really kind of seem like two poles outside of when you're dealing with justiciable rights. And I feel like there might be something in the middle that we would maybe want to move to. And I'm very, very interested to read the committee's emerging jurisprudence because I think that's going to be a really important source of interpretation and of development of the enforcement and interpretation of rights, of these rights.
Sure.
I was thinking, just to come back to your, I've only used HIV as an example, but in fact you can find equivalent policy changes and reformations in other fields, including TB. Those are the two big main priority areas. So where you find there's been major changes in policy of TB management has been, for example, in the field of diagnostics. We've now had gene experts rolled out our country, including in prisons. We've got access to TB drugs, and initially it was part of a very confined program that's now being rolled out. So South Africa became the first big country to actually roll out bedaquiline in a big way. So I think that has been a very interesting way of also looking at the impact of human rights in the field of facilitating and also flexible policy making, that you've got to be responsive. And for me, when you speak about the difference of the elements of rationality and reasonableness, they're not incompatible, but you'll find that where I found that the courts have been quite good is in saying, well, what constitutes rationality is usually you find evidence-based decision-making. So if there's evidence for something, especially scientific or medical evidence, then your policy-making should be based on that, because that makes the policy-making rational. So it's not only about reasonable, but it's about rational as well. So scientific decision-making has been quite key to informing government choice, and that's happened in the field of TB, and it's also now beginning to happen in primary health care, etc. So there's a range of other diseases where this has happened. People just very briefly spoke about the Minister of Health now intervening in the regulations of salt content, smoking regulations. It is quite widespread in many other fields.
Yeah, I think, sure, well, just to add to that, I think the ideal is that our courts will always make rational decisions based on evidence, or so we hope. But I have appeared in front of the court where they have simply ignored the evidence. And it does not necessarily come out in the judgment, because it's simply not mentioned. That is what most academics will look at. But if you look at the papers that were filed under the heads of argument, then you will see that there were arguments and evidence before the court that was simply ignored. So we must just also know that South Africa isn't always the ideal utopian state in society. So for instance, on your point of the NTA being controversial, I agree 100%. That NTA that was published by government is controversial, but of course currently it has a certain status. There are other controversial developments as well, such as the ASAF report. I think you were perhaps a co-author of it. That ASAF report that deals with genomics and genetics research in South Africa has been received as a very controversial position, especially regarding things such as benefit sharing by research participants, politicizing the issue of ownership of one's biological material, politicizing the idea of intellectual property in one's genes, and going so far as in fact suggesting that individuals' genetic information should be managed as a national resource rather than as an individual resource. So there's still a lot of debate in South Africa, in health circles, and it's quite vital.
Without compensation.
Beg your pardon?
Expropriation without compensation.
It sounds like that. Yes, it sounds like that. But of course, we South Africans are always very optimistic to find solutions and to find ethical and legal solutions.
Yeah, first of all, I would encourage you to talk with Alicia during the break, because she knows a lot more about Latin America than we do. My Spanish is simply not good enough, but I understand Portuguese relatively well, so I really only know about Brazil. And I think it's really relevant what is happening there within the context of the discussion we're having, because in Brazil they're using health technology assessment as an answer to these individual litigation cases, and they are supposed to empower the Ministry of Health to be able to show this treatment doesn't fall within the scope of our budget and with all the alternatives we have. The problem with health technology assessment for me is double. First of all, it's focused on technology and not on wider public health interventions that may be far more efficient, etc. That's not included. And the second is that they usually start with a given budget and then make their calculation based on this budget without questioning whether that budget is sufficient enough. And so for me, that's one of the reasons for promoting the reasonableness approach, but make it slightly more demanding and link it with non-discrimination. And then you can use tools like health technology assessment to fight against excessive individual claims, but not go to the other extreme where it's simply a calculation based on a health technology assessment that allows then a court to say we're not going to provide this. So as usual, I think the answer is somewhere in the middle.
This was an exciting conversation in many ways, helping us to focus on global health law through its application here in South Africa. Please join me in thanking our amazing speakers. we have about 20 minutes for a break. As Janwood said, it is upstairs.
Fourth floor.
It is on the 4th floor. We are going to reconvene here in 20 minutes to talk about ethics, health, and non-state advocacy. Thank you again.